Welcome to Middle Class Matters Business News in English from Dr CMA Alagesan. Securities Exchange Board of India (SEBI) issues confirmatory order in respect of Mr. Subash Chandra, the chairman, and Punit Goenka, the managing director, in the matter of ZEE Entertainment Enterprises Limited. Part number 17 continued. 83.2 Rational nexus between the rights infringing measures and the state aim. The prima facie contact of the entities has shown that the entities have prioritized their own interest above the interest of the public shareholders of ZEE, which constitute 96% of the shareholding of ZEE Limited. Moreover, several other LOCs given out by the entities are being scrutinized by SEBI. Therefore, prima facie, the contact of the entities is not suitable for them to be part of a listed company, as the repercussions of the wrongdoing are not restricted to that particular listed company but reverberates across the securities market. On the other hand, SEBI has the primary duty to keep the securities market space safe and secure and build investor confidence. The aforesaid is important for the development of the securities market. Looking from the above perspective and considering that a free and fair investigation is imperative in the matter, one can see a reasonable nexus between the temporary restraint imposed on the entities vis-a-vis the primary objective of SEBI. 83.3 Rights infringing measure should be at the least restrictive measure open to the state to achieve its goals. To begin with, the directions are temporary in nature, pending final outcome of the matter. Further, there were several other measures which could have been taken against the entities under the provisions of the securities laws. Example, debarring the entities from accessing the market or dealing in securities or being associated with the securities market in any capacity, including being associated with an intermediary, etc. However, in the given facts and circumstances of the case, which at prima facie cast a doubt on the contact of the entities to be part of the management of a listed company, it was deemed appropriate that the temporary restraint be imposed on the entities. 83.4 Balance should be there between the extent and severity of the infringement and the state aim. The restriction that has been imposed upon entity number 1 seeks to only keep him away from exercising any influence over the management of ZEE Limited, which is possible owing to his connection or relationship with the promoters of ZEE Limited and also by virtue of his long association with ZEE Limited. The direction is aimed at ensuring a comprehensive investigation in the matter. With respect to entity number 2, the restriction has been imposed looking into the prima facie findings against him in the interim order. Not only he prima facie failed to disclose all the material developments with respect to appropriation of fixed deposit by Yes Bank to the board of directors of ZEE Limited, but the subsequent measures taken by him did not address the issue at hand, nor was any effective investigation done to find the root cause of the problem. Further, the LOCs issued by him are also being examined by SEBI. Thus, when one sees holistically, the temporary restraint imposed on entity number 2 is proportionate to the malaise that SEBI is trying to remedy in the instant matter, that is, entities not adhering to basic principles of securities market and corporate governance norms. 83.5. There should be provided sufficient safeguards against the possibility of abuse of the rights infringing measures. As discussed in preceding paragraphs, measures that SEBI can take are circumstanced by the objective for which SEBI has been set up. I have also discussed at length in earlier paragraphs as to how the measures taken by SEBI are preventive in nature and towards achieving the objective of SEBI Act. Thus, I find that the measures taken by SEBI are within the confines of SEBI Act. 84. In addition to the above, it has been contended by the entities that since there is no violation of the PFU-TP regulations or the LODR regulations by the entities, there is no correlation between the directions passed in the interim order and the alleged violations, and the directions are excessive. 85. With regard to the above submission, I note that the interim order has given a specific finding that the actions of the entities are in prima facie violation of PFU-TP regulations and LODR regulations. In the instant proceedings also, the entities have not been able to refute the prima facie findings of the interim order. Since there is a prima facie violation of the provisions of securities laws, it necessitated issuance of directions against the entities. As discussed in the preceding paragraphs, SEBI under section 11(1) and 11(b) of SEBI Act can take any measure which it deems appropriate in the given facts and circumstances of the case to achieve its objective of investor protection and promote the development of the securities market. It has been observed that the entities have prima facie not met the expectations of operational transparency in their dealings with the board of directors of ZEE Limited as well as with the shareholders. Further, they have not made adequate and timely disclosures. Rather, the disclosures were made on a piecemeal and misleading manner. Moreover, their interests have put them in direct conflict with the interest of the company and its shareholders. Thus, considering the overall context of the entities and its impact on the integrity of the securities market and confidence of the investors in general and ZEE Limited in particular, pending detailed investigation, the actions of the entities did warrant the issuance of directions. Hence, I do not find any merit in the submission of the entities in this regard. Urgency for issuance of directions. 86. As discussed in the preceding paragraphs, after consideration of the observations recorded in the interim order and the submissions in that regard made by the entities, there exists a prima facie case against the entities. In this backdrop, I now proceed to address the submission made by the entities that there was no urgency in the matter which warranted issuance of the directions via the interim order. 87. The prima facie findings have shown that entity number 1 had issued LOC without the knowledge of the board of directors of ZEE Limited. It is on record that even entity number 2 had issued LOCs to banks. Both the entities have, as a matter of practice, issued LOCs to bank to help the companies related to them. The said LOCs are being examined by SEBI. Further, as noted in the interim order, both the entities were involved in the prima facie scheme to benefit their associate entities at the expense of ZEE Limited, and in the process they have misrepresented to the shareholders of ZEE Limited and have made false disclosures. Thus, the prima facie actions of the entities are against the basic tenets of the securities market, that is, transparency in dealings and making sufficient disclosures. 88. In this backdrop, I note that every managing director or a director or chairman or member of the board of a company owes a fiduciary duty towards the shareholders. Essentially, the position of a director is founded on trust and confidence reposed in such person by the shareholders. In the present case, as discussed in the preceding paragraphs, the conduct displayed by the entities in managing the affairs of the listed company seriously jeopardizes the trust that the shareholders repose in the chairman and managing director of a listed company. As noted, prima facie, the entities were responsible for employment of the scheme, which has jeopardized not only the interest of 96% of ZEE Limited shareholders but has also caused irreparable injury to the integrity of the market and confidence of the investors. In general, SEBI, as the securities market regulator inter alia, seeks to protect the interest of the shareholders of listed companies. One such interest that SEBI has attempted to safeguard in this case is to take into account the trust deficit that has been caused on account of the conduct of the entities described in the interim order. The directions issued while the interim order also seek to reinstate the belief of the shareholders that affairs of a listed company have to be managed in accordance with law, and SEBI as a regulator cannot allow such listed companies to be operated like sole proprietorships. 89. In the instant case, urgency of issuance of the interim directions is not to be assessed from the point of view of the transactions per se. Rather, it is the egregious nature of the transactions which came to SEBI's notice as explained in the interim order, which display a total disregard to the accountability of the managing director and chief executive officer and the chairman to the shareholders of a public listed company in which more than 96% of shares are owned by the public ZEE Limited's assets to the extent of INR 143.9 crore have been depleted on account of the transactions noticed in the interim order prima facie for the benefit of the related parties of the entities. The interim directions seek to prevent the entities from abusing their positions in respect of a public listed company in an unbridled manner without bringing key issues to the notice of the board and risking the assets of the listed company to the benefit of the private limited companies directly or indirectly controlled by them. 90. It is stated that under the leadership or control of the entities, the affairs of ZEE Limited have not been carried out in the best interest of the shareholders and the company as such. In fact, to the contrary, the entities have prima facie orchestrated the scheme to cover up the direct loss to ZEE Limited on account of the appropriation of the fixed deposit towards loans taken by associate entities. 91. It is seen that entity number 2, who was MD and CEO of ZEE Limited at the relevant time, as well as till the passing of the interim order, has prima facie not been diligent in taking steps to adequately address the issue at hand, which is not in the best interest of the company as well as its shareholders. Further, he is also prima facie involved in the scheme which puts his interest in conflict with the interest of the company. Similarly, entity number 1 was part of the management of ZEE Limited. Prima facie did not take any effective steps to bring to light all the material facts of the matter to the board of directors of ZEE Limited. As noted, he is prima facie involved in this scheme, which puts him in conflict with the interest of the company as well as the shareholders. Please like the video, subscribe to the channel, and share it to your friends who are interested in taking part in the equity market, because this will be an eye opener for those who are investing in share market. What are the matters to be taken into account before investing and after investment also to protect their investments. Thanks for watching.